Ladies and gentlemen of the internet, today I present you the court case of the century. The accusation? False promises, emotional damages, blue balls, and a pattern of misleading statements. Today we turned my Discord into a courtroom and we went all in. Objections, cross-examinations, dramatic speeches, all of it. Before we begin, let's go over the rules. Firstly, each team is awarded 3 timeouts, aka recess. Each timeout can last 5 minutes. Second, each team is allowed as many objections as they want, but if the judge denies 2 of them, they must remain silent for the remainder of their term. And finally, each team is allowed as many witnesses as they want. However, each witness must have a different voice and a different costume. Without further ado, let's jump into it. We're live! Please, we'll let the Honorable Judge Robert take the claims. Read out the claims. What is Christian being sued for?
Well, today we're coming to here to prosecute against Christian for not holding up his end of the deals and giving satisfaction to David.
Exactly. Rose Buren. Your Honor, he's ore farming.
Will the
I'm frame maxing.
like to start us
ASU.
off?
Wait, who gets to start us off?
Plaintiff?
Okay, great, that's me. So, let me read off my oral argument.
Oh, oral, huh?
David files the original petition of defendant Christian, and the cause for action will respectfully show the court the following. Plaintiff David is an individual residing in Texas. Defendant Christian, whose last known address is a shoebox, jurisdiction and venue. The court has jurisdiction because the amount in controversy is within the limits of the Justice Court of Texas. Facts. On or about February 26, defendant agreed to provide certain services to plaintiff. Defendant was reliant upon these services. Defendant failed to provide the agreed upon services and has not refunded the payment despite request. Defendant's failure to perform constitutes a breach of agreement. Defendant has entered into an agreement with plaintiff and accepted the terms. Defendant failed to perform the agreed services, thereby breaching the agreement. As a result, the plaintiff has suffered damages in the amount of $68,000. Plaintiff seeks monetary relief in the amount of services not rendered, court costs, and medical bills totaling $68,000. Plaintiff respectfully requests that the defendant be cited to appear and answer that upon final hearing, plaintiff recovered judgment against defendant for damages, court costs, and any other relief which plaintiff may be entitled to. Okay.
And defendant. What is your rebuttal?
Oh, it's mine. I didn't hear. You're over. You know. All right.
Or did you finish, plaintiff?
Yes, I finished, Your Honor.
Okay.
Okay.
Go on. Your Honor, permission to treat the defendant as hostile.
Your Honor, plaintiff cannot identify any specific defined promise. Any alleged statement was casual and not contractual in nature.
Is that it?
Was that all?
Yeah.
Your Honor, I would like to point out that in the state of Texas, verbal contracts are legally binding contracts, and I have text messages and video evidence of these contracts being made. Do I need to play them for the court?
Yes, I think we need to play them for the court.
Okay, I'll start with one. Oh yeah, why don't you tell me how much you want to fucking blow me?
Huh?
I'm ready. I need it.
I want to blow you so fucking bad. Oh, please, please, just let me fucking hit you, please.
Oh yeah.
Please.
When and where? You give me a time and I'll fucking do it.
Big John. Big John. Big
When and where,
John.
motherfucker? When and where?
Right now, right here, right now, right in front of the Smicks. Please. I'm an alcoholic.
Okay. Alright. There's no defending that. I asked for a time and place and he said right here, right now. And that's just one of many. I'll let the defendant plead his case.
Defendant, what do you have to say?
Okay. Your Honor,
I will also
even
like to state that you
that statement as authentic.
What was that, Your Honor?
I would also like to state that the defense I've seen has not submitted much evidence to me, as I'm also supposed to also overview this.
Well, Your Honor, I'd like to point out that the defendant knows damn good and well he said and meant all of these things, and he's just being a cheap bastard, Your Honor.
Your Honor, even accepting that statement as authentic, the issue is not whether words were spoken. The issue is whether those words constitute a clear, definite, enforceable promise that makes the defendant liable for medical damages. And did I? I'm going to ask a few questions. Did I specify it? Never mind. I did. Fuck. Did I specify exclusivity? Did I? Did I specify?
Objection. Defendant looks like a little bitch right now.
Sustained.
Did I specify consequences for non-performance? Did I receive consideration? Did I prevent plaintiff from seeking alternatives? If none of those, the statement lacks definite terms, and therefore cannot create promissory estoppel liability. Even if a promise existed, hospitalization and $68,000 in medical treatment are not natural and probable consequences of a failed social favor. That is all, Your Honor.
Okay.
Okay.
Plaintiff?
Well, if I may say, that's not a very good defense. While he did not prevent me from finding ulterior motives or ulterior sources, he did promise me these services. Now, Your Honor, I'd like to ask the court, if you order an Uber, do you call your friend for a ride? No, you don't, because you have a reliable source of transportation coming your way. That is exactly what happened here. He promised that he would be there, so I had no need to look for other sources.
Objection relevance? What the fuck?
I don't think he sustained it.
No, I don't think I'm saying that one.
Okay.
What?
Meaning you lost an objection. You got one more.
Okay.
Okay. Let me bring up my Okay. Let's see. Okay, on or about February 26th, defendant made a clear and definitive promise to plaintiffs to perform certain services. Defendant knew or should have known that plaintiff would rely on this promise. Plaintiff reliably relied on defendant's promise. As a direct result of defendant's failure to fulfill this promise, plaintiff suffered a severe and unexpected medical condition. Plaintiff required hospitalization for approximately 8 weeks. Plaintiff incurred medical expenses totaling approximately $68,000. Plaintiff lost wages due to inability to work. These damages were a direct and proximate result of plaintiff's reliance on defendant's promise. Upon being informed of the damages suffered, defendant failed to take responsibility and instead responded dismissively. I seek $68,000 for medical bills, $4 for lost wages over the 8 weeks that I missed, and court costs. That's all, Your Honor.
Does the plaintiff have any witnesses of these so-called abnormalities?
Unfortunately,
What?
plaintiff does have a witness. Your Honor, can the defendant say his rebuttal to that sentence as I grab the witness?
Yes.
All right, defendant.
While he ore farms.
Put the aura farming. Defendant.
Your Honor, I would like to rebuttal the Uber statement and also the medical bills. But first, we're starting with the Uber comparison and how it's a weak comparison. Uber is a commercial service with payment, with defined terms, with acceptance, with obligation upon request. My situation,
You cut out that.
Objection.
contract terms.
Defendant has shit internet. Request that defendant re-say that last statement.
Yes, can we hear that last statement one more time?
Our situation allegedly has no payment, no formal acceptance, no contract terms, no commercial structure. Your Honor, the Uber analogy is inapplicable. Uber is a structured commercial service involving payment and contractual obligations. The alleged statement here was informal and lacks those elements. Therefore, the comparison is misleading. All right.
That's it.
That's my rebuttal. Yep.
Does the plaintiff have anything to say for that?
Your Honor, I could bring in my witness if you'd like, or I could bring up the sign of him promoting his own business, saying what he gives out. I could go either one, Your
We'll
Honor.
start with your witness first, and then we'll move on to your rebuttal.
Can huge horde come to the stand? Hi, Your Honor. My name is Huge Horde, and I'm a massive slut.
Hello, huge whore.
I, Huge Horde, declare the following. On or about February 26, 2026, I was present during a conversation between the plaintiff and the defendant. During that conversation, I personally heard the defendant make a clear and direct statement indicating his intent to perform personal services for the plaintiff. The defendant's statement was made in a serious manner and not as a joke. Based on the tone and context of the conversation, it was reasonable to understand that the defendant intended for the plaintiff to rely on this promise. I affirm that this statement is true and correct to the best of my knowledge.
Okay, but what did that have to do with anything about the abnormality of your situation? for what you've had to go through for the hospital records.
Well, Your Honor, that was just my witness statement. That was what my witness had to say.
Okay.
As far as the abnormality, every time I would ask, when are we doing this, he'd say right now, and then I'd show up, and he wouldn't be there, or he'd be denying. So, of course, I just kept believing that he would put out. But he never did. Eventually, it got to this point, where my balls were so swollen, so blue, I could not urinate anymore, and I had to seek medical help. That's all, Your Honor.
And who had to witness this exactly?
That was huge whore, Your Honor.
Okay.
He's a slut.
And your rebuttal from the defendant's last accusations?
Well, to be honest, Your Honor,
I would like to speak.
Hey, he did not say objection, and I was not finished.
He is right, defendant. He did not say objection. And he was not finished with what his statement was.
Admission to treat the defendant as hostile?
If there has been no regards of safety harm, no. But the defendant will be mute because he's a bitch.
Well, I was going to say, go fuck yourself, defendant. But anyway, I shall continue. I have here, the
defendant. Don't have me have you held in contempt with a middle finger.
Let's see.
Please continue.
So, my statement is defendant regularly suggests that he makes these. In fact, on numerous occasions, defendant has called himself quote unquote community puh. And he presented these in such a serious manner, making it seem like I wasn't the only one. Now, Your Honor, if he was just busy, that's one thing, but every time I show up for agreed upon appointments, he would just blow me away. And I don't mean in the way I asked. That's all, Your Honor.
Okay. Defendant, you may now speak.
I would like to speak to the witness, Hugh Hoare.
1 second. Fuck. Damn it. Boy speaking.
Almost like oh.
You're friends with the plaintiff, correct?
Yes, that's correct.
And you want him to win this case, correct?
Yes, that's correct.
Your Honor, I would like to stay biased. Get this bitch out of here.
Your Honor, I would like to point out that the defendant could have brought any witness of his choosing, but he could not find a single person to defend him in this matter. Huge whore is another one of his victims.
Hey, I didn't finish.
He did not finish, and you did not say objection.
I thought he did finish, but please continue.
What exact words did I use?
Wait, you told her, get that whore out of here. She's gone. You said get that whore out of here.
Get this bitch out of here.
Your Honor, I'm not crazy, right? He did say those words.
Oh, fuck, I threw her away. I thought she was still here. Oh, no. Oh, fuck.
He did tell her to leave.
If
I'm
it
now
is to the
I'm
court's
fucking myself.
pleasing, I can bring back the witness.
Does the defendant want to continue his conversation
Yeah.
with you, whore?
Yes.
Son of a
I was just getting a
bitch.
little. Just get.
What do you want? What do you want, slut?
All right. What exact words did I use?
Well, I was working the corner that night with you, I might add, and he showed up, and your exact words were, "Oh, honey, I'm the community puh. You can do whatever you want to me. I'll even blow you, and I won't charge you a single thing."
The defendant.
Now,
Do you have anything to refute against it?
okay. Why wouldn't you also offer your services? Isn't that what you say
Because I
to a client,
charge.
a potential client?
I charge. You gave it out for
Mhm.
free. Say what you want about the plaintiff, but he's a cheap bastard.
Did I state
Objection.
exclusivity?
Objection, harassing the witness. He was laughing in the witness's face.
No, I don't
Objection,
think.
he's drinking in the courtroom.
I'm not drinking in the fucking courtroom.
Your Honor, he's drinking in the
Sustained.
courtroom.
We're allowed,
That
we're
will be
allowed to have
sustained.
refreshing. Well,
Yes.
we're allowed to have refreshing.
We are allowed to have refreshments, but we're not allowed to have alcoholic beverages. Would you like to? Okay, fine.
Did I state exclusivity? Huge whore.
No.
Did he take off the wig again?
He took off the jacket.
I didn't say I'm finished with my questions.
Can you repeat the question, please?
Your Honor, this witness is being retarded. Did I state exclusivity?
For that night, you did. In fact, I believe the exact words you used were, "I'd throw away 7 years for one night with you." End quote.
Your Honor? No, sorry, not Your Honor. Hugh, did I state consequences for non-performance?
I'm a streetwalker. I'm not supposed to know what that means.
Basically, did I say what would be the consequences if I did not perform? Simple. It's fucking retard.
No. But then again, you never
I
said
would-
you weren't going to perform.
Your Honor, I'd like to I'd like to send this back to the plaintiff.
Okay. Plaintiff.
All right. I'm going to go
Hey, that
ahead.
jacket's all on. That's a different person.
I'm going to go ahead and dismiss the witness. I don't have any questions for the witness. I think her testimony is enough.
Okay.
And you know what? Just to make things interesting, how about we go ahead and we'll bring up a photo taken that very night of the defendant. If you would be so kind as to look at what I submitted at 12:55 a.m. on February 26th. This is him standing there on the corner holding a sign that says "Free Handy." And if you pay very close attention, to his shirt, it says "In and Out Lubrication Expert." Same thing on his hat. Meaning, this was a business that he was running. He has been doing this for years. Long enough that he got a company uniform. And he's out here marketing for his business. That's all, Your Honor.
Defendant?
Your Honor, I'd like to state that uniform was me after I got home from work at an automotive lubricant shop. Okay, that was not part of my business. The free handy sign, that is honest to God, right hand on the Bible. Hey, it's AI. He brought fake evidence into this court.
Do you have a way to prove that?
No, Your Honor.
Then we can only assume that it was generated by AI and not directly influenced by AI.
Your Honor, even taking this at face value, the sign says free. That indicates no consideration was exchanged. Without consideration, there is no binding contract. A sign without specific terms, date, exclusivity, or defined performance is not a definite offer. It is vague and lacks contractual specificity. Specificity. A joke, a vague statement. I see. Yeah. That's all, Your Honor.
Okay. Plaintiff?
Well, I'd like to point out, defendant said he was wearing that when he came home from work. If we go back and look at the photo, does this look like a driveway? Does this look like an apartment complex? No, Your Honor. This is a parking lot with trees in the background. So I'd like to point out that statement, first and foremost.
Home.
He's not wrong.
I came from work.
Your Honor, what did he say? It cut off in the beginning.
I don't think he said anything yet.
Oh, I said objection. I came from work. I never stated I went home.
Nope, that's a lie. Your Honor, plaintiff defendant is a lying bastard. He did say, I just got home from work, from my mechanic job. He said home.
Defendant?
Your Honor, I'd like to state that uniform was me after I got home from work.
And if we do look back at the coroner, it did state that he went back home.
Also, Your Honor, taking this photo at face value, it does say he was giving these out for free. Now, while there's no contractual evidence from the photo, he did clearly state it. He clearly said, I will do this service for you for no charge. Why, if somebody's promoting that, why would I not look into it? He regularly makes these patterns. I have mountains of evidence. Your Honor, if we look back and we look at what I put in at 1:03 a.m. on February 26th, there's a video. I'm going to play it for the court now. Please.
On your Discord, yeah? How about you scratch my ass and do me the favor?
What?
Scratch and sniff.
When? I'm
asking
ready.
you to scratch.
I'm ready.
Scratch and sniff.
I'm ready.
You stupid fuck. You have no idea what you just agreed to.
Oh, I know what I agreed to. Are you willing to put out on your end?
No.
He said, I have no idea what I just agreed to. Because he was going to let me scratch and sniff his asshole. And Your Honor, he did not fulfill that promise. I kept saying I was ready, and he kept backing out. Your Honor, this man has made promise after promise, and I have fallen victim to that. I have fallen victim. You know, to this day, I still have to piss out my ass. Your Honor, defendant is bullying me. He's laughing at me.
Sustained.
Okay, that's all for now, Your Honor.
Defendant.
Your Honor, even if I've made statements on multiple occasions, there was no clear acceptance tied to specific terms, no consideration exchanged, and no defined time, place, or conditions of performance. Casual statements, even repeated ones, do not form binding agreements. Did he accept? Did he agree to a date? Did he give something in return? Did you restrict yourself from offering somewhere else or elsewhere? And and that, hold on. A statement without defined terms is at most a gratuitous promise. Gratuitous promises are not enforceable. That is all, Your Honor.
Okay, plaintiff. Do you have a rebuttal?
Okay, I did, but then I kind of spaced out because his voice is weird. But anyway, if you
Sustained. Sustained.
if you look back at the court evidence, I did agree to a date. I did in the very first video I showed, right here, right now. And when did I upload that? Oh, look at that! It's on the same date of the current incident. 1:17 a.m. 2:26, which is when all this took place. All this took place. He agreed, and because I said right here, right now, and he agreed to it. Your Honor, we cannot allow this to continue to go on. Well, no, he did not prevent me from going forth and finding other candidates. Why would I? When he agreed to the specific date. And while, yes, I was not going to give anything back, he was offering it for free, so why would I? Now look, me being the nice person I am, I would have tipped him. Not monetarily, I would have given him tips on how to do it better, but a tip is a tip no matter what. That's all, Your Honor.
Defendant, do you have a rebuttal against that?
Even if plaintiff's version of events is accepted as true, for intimate service agreements, such agreements are void as a matter of public policy. Even outside public policy, personal services contracts cannot typically be specifically enforced, meaning a court cannot force someone to perform personal services against their will. At most, damages could be considered, but there was no payment, no consideration, no measurable damages. And you can say that the $68,000 of medical damages were linked to me, but there was no date and time. Why didn't the plaintiff mitigate damages by getting it checked out sooner? Why didn't he go to other reliable sources besides me? He didn't have to have a promise. I wouldn't know. I wouldn't know if he wanted to go fuck some other dude. That is all, Your Honor.
Plaintiff?
Your Honor,
Do you
I like
have
to
a
say
rebuttal?
I did not search for other plaintiffs because you try and find another 4-foot tall whore, alright? It's not possible. Not his size. Okay? And second, he has no evidence that I didn't go get it checked out immediately, which I did. The minute I realized I couldn't piss is the minute I realized, oh, I have a problem. Look, every guy who's truly a man has been blue ball before. But my blue ball was taken to an extraordinary circumstances because he kept promising and I kept trying. And I kept trying. Okay? And as far as against his will, whatever that means, clearly it wasn't because he was offering the services. He was offering them. Which means it's not against his will, it's exactly what he wanted. That's it, Your Honor.
Defendant.
Your Honor, I would also like to add, plaintiff has not established causation between any alleged statement and his claim of medical damages. Ask yourself, did anything actually happen? Is he claiming emotional distress? Is he claiming physical injury from the event? Is he claiming stress-related medical issues? Blue balls is not a stress-related medical issue. He must provide a direct link with medical records showing your actions caused the injury.
Do you have any evidence
That is all.
blue balls does not cause stress?
Are you talking to me?
No, defendant.
What?
Your Honor, I don't need to see defendant's balls right now. Objection, Your Honor. Unattentive and kind of short.
What does that have to do with anything?
Listen here, banana peel. No one's talking to you.
No, I love it.
Is that all?
No.
Defendant?
Yes, that's all. The plaintiff.
Okay, so he could not show proper evidence that blue balls is linked to stress. Now, unfortunately, I can. But the problem is, I forgot to submit it on time. So, I will say, in fairness, I can't, in good faith, show my doctor's note. However, I will want to say this. Defendant is not a doctor. Defendant cannot prove that blue balls is not related to a different church-related issue. If all this happens in the same...
For doing mockery.
Your Honor, he's frame-mogging, and it's kind of scaring me. He's self-promoting. Anyway. As I was saying... It is not fair, Your Honor. How can this be fair to me? All this stuff happened on the same night. It is not coincidence that all this happens in one night. It's all because of him and his false promises. That is all, Your Honor. I'm making all the shit up as I
If you
go.
ever want to call recess to reorganize y'all's paperwork, you're more than welcome to do so.
Your Honor, I would like to submit evidence D.
Oh, God.
What exactly is evidence
Your
D?
Honor, I can't play that on stream, nor can I have it be played. But go ahead and play it.
Where is evidence D
Evidence-
exactly?
He is talking
At
about
1:17 a.m.
one of the only things that he submitted. However, I might have to deafen you because there's no way I can play that on stream.
I see what you're going to talking about.
Mm-hmm. Your Honor, if he had so-called blue balls. Why did he find other sources to give him favors? On the 26th, same day.
Objection,
There is a
hearsay.
recording. I'll allow it.
Hearsay. Your Honor, I would like to hear why he said objection hearsay.
Okay, here's the thing. Show me the evidence that that was recorded on that day. No. In fact, I believe that was recorded on February 21st, 2026. Approximately 5 days before I came to see you. So, with that being said, that cannot be tangible evidence. Because, as I said previously, that was recorded on an earlier date.
And when did you say this promise that I gave you?
February 26th, and I can show you the timestamps on all of it.
Lies.
Your Honor, permission to add a couple more things to the evidence thing. All I want to add are the time dates that these things were taken and created.
You would have to
Everything.
use one of the recesses.
You know what? I'm gonna go off my intuition and the fact that you were there, Your Honor, so you know exactly when this was taken. So, I will go off of that. I would go ahead and give it back to the defendant, but I think he's crying right now because he just realizes he's gonna have to put out in front of the court or give me $68,000. But bro can't even finance a toothbrush, so
Your Honor, I would like to call a recess.
Okay.
all right. It is currently 10:50. You have till 10:55.
Perfect.
All right. So
Plaintiff, that also means you can reorganize your material if you need to while recess is commencing.
yes, Your Honor. All right. So here's the problem that we're reaching now. Okay. Problem is this. I'm winning. I don't know what I'm gonna do with these 5 minutes. I mean, I guess I can make it better. So I guess I would say it'll fix it. Saying that I had other sources and did not use them, but the evidence is not right. Okay, so the alliance is reasonable. The defense has no actual evidence. Yeah, I should also mention the defense has added one video which took place long before the incident. Okay. I said that. I haven't even been using ChatGPT that much. I mean, yes, I used it in the beginning, but here I haven't used it that much, and it's basically saying everything I've already said. The defense starts leaning on old, unrelated evidence. It usually means they don't have strong evidence. Exactly. He was given days. He was given a long time. And okay. You can use it. The defense is both unprepared and trying to compensate with irrelevant evidence. Failure to present. Oh my god, that's something I can use? Oh my god, I'm gonna use this. I'm ready, Your Honor. Okay.
We're still having to wait for defendant. He
Yes,
still has 2 minutes left.
defendant still has 2 minutes. Holy crap. Okay. Alright. This is exciting. I think I could win this. He was given days. I mean, we planned this thing almost a week ago now. Monday. I think we planned this on like Wednesday. And then it just kept getting pushed back and pushed further back. So we didn't plan this on Wednesday to do it on Thursday, and then it got pushed back. We couldn't do it Friday or any of all this weekend. So he had the time. He's just chosen not to do it. And I've reminded him numerous times and said, you're cooked. I could have added more, but I felt bad. I felt bad because I had all this evidence just stacking up against him. Okay, how many seconds does he have left? I don't know. I'm waiting. Oh well. Oh. Time's up, Your Honor.
Defendant.
I am ready, Your Honor.
All right.
Well,
The internet's gone even worse.
we
What?
left it off with you. So
Yep.
what exactly?
Yeah. Okay.
Let me. There we go.
Your Honor, plaintiff has admitted receiving similar services 4 days prior. This introduces a clear alternative source for any alleged medical condition. Plaintiff cannot meet his burden of proving causation.
Is that all?
I got some more. The burden of proof is on the plaintiff. Speculation is not sufficient to establish medical causation. Let's see. Your Honor, plaintiff has presented. He has. Hold on. My lawyer is retarded. I guess it doesn't remember the medical evidence that you put in. Sorry, give me 1 second.
Your Honor, can I go now?
Plaintiff's claim is speculative. Hold on. I got it. I included it because I was reading it. Plaintiff claim is speculative and unsupported by medical evidence. No, resulting from his own arousal does not create liability. There's no enforceable contract, no recognized injury, no legal duty. Plaintiff has failed to meet his burden.
That it?
For now, yes. That's all. That's all, Your Honor.
Okay. Plaintiff.
Well, I like to point out that failure to present evidence. Your Honor, the defendant was given ample time and multiple opportunities to prevent relevant evidence in this matter. Despite that, the defendant chose to assert that no evidence was necessary. Now, at this stage, the defendant attempts to rely on untimely and irrelevant material that does not address the court issues before the court. This is not a substitute for meeting the burden of defense. And then I'd also like to say, Your Honor, this defendant repeatedly argues there is no enforceable contract, but that is a mistreatment of the claim. This is a breach of contract case. This claim is based on a promissory estoppel. That's all, Your Honor.
Defendant.
Your Honor, the medical document does not establish that I caused the condition. It only documents that the plaintiff experienced temporary discomfort.
Objection. He can't use that evidence because it's not in the court evidence.
He is right.
I wasn't allowed to submit it, so you can't use it.
Well, that makes more sense. Then you haven't uploaded any. I'm gonna tell my and I was telling my lawyer correctly that you haven't submitted any medical evidence. So
So there's no records of him having any medical issues. And the Wi-Fi for the defendants is becoming shit again.
all right, bud. Yeah, right. No, it's because somebody keeps calling me.
I have a feeling I know who. Defendant, would I be correct in making my assumption? Plaintiff, I think he's stalling.
Yes, I think he is too.
Can you hear me?
Now we can.
Someone keeps calling me. That's why.
It. Okay, well. It's still your turn. You can give it back to me if you want.
Yeah, we can toss it back to the plaintiff as
Your Honor.
gets put together.
Your Honor.
Yes, defendant.
The plaintiff has shown that he's experienced temporary discomfort. He has not shown that I owed him a legal duty, that I breached such a duty, or that my actions were the proximate cause of his condition. That is all.
Plaintiff.
Well, I'd say this. I'm not relying on a general duty. I'm relying on a promissory estoppel. The duty can arise from a promise. When a person makes a clear promise expecting reliance, the law imposes a duty to avoid causing harm through that reliance. The whole foundation of the promissory estoppel. No contract needed. This is not negligent. This is not negligence. It's reliance. Duty was created by his own words. Defendant created the duty himself by making a direct, indefinite promise, knowing the plaintiff would rely on it. This flips onto him. Tie it together. Once that promise was made, the defendant had a duty not to induce reliance, then disregard the consequences of that reliance. That's all, Your Honor. Wipe the floor with this. Never mind. Continue.
Sounded a little hostile, but defendant.
All right. Your Honor. For a promissory estoppel requires all of this: a clear and defined promise, reasonably relied, and he had to reasonably rely on that promise. That reliance was foreseeable. That reliance caused actual deterrent, and justice can only be avoided by enforcement. A vague statement like "I'll give you favors" or holding a sign that says "free handy" is not definite. No time, method, duration, conditions, or exclusivity. The alleged statement lacks defined terms and therefore cannot constitute a clear and definite promise. It has to be reasonable reliance. Was it reasonable for him to rely on? A casual statement, a sign saying free, no written agreement, no exchange of value. Would a reasonable person believe that this was a legally binding obligation? Any reliance was not reasonable under these circumstances. This kills his argument of promissory estoppel. Foreseeability. You can reasonably foresee that he would develop a medical condition. Nobody could
I got
foresee.
this now. I got this now.
Not offering.
Oh yeah.
Not completing my offering.
Could cause. I'm gonna call him to the stand.
Medical condition.
I'm gonna call him to the stand.
Why didn't plaintiff Why didn't
And I
plaintiff
think that's
do
allowed
something to mitigate
because it's him.
this
It's not another
so-called
witness.
damage? Why did he
It's
wait
him.
this much time for medical bills and everything to build up to $68,000? The alleged harm was not reasonable or foreseeable from a casual statement. Did he
Bro
quit
keeps
his?
fucking
Did he
yapping.
quit his job? Did like he didn't? He didn't have to leave work because of this and lose 4 days' pay. Your Honor, plaintiff has
8
failed to
weeks
establish
pay.
a clear and definite promise.
Well, somebody's
Your
being
Honor,
asked.
plaintiff has failed to. Yes, he spoke out of turn. Reasonable reliance or foreseeable and sustainable deterrent. Promissory estoppel does not apply. That is all, Your Honor.
So what I'm gathering from both sides is that both of you agree that there has been some abnormality that has happened to the plaintiff.
Ooh. Your Honor,
Correct.
I would like to call another witness to the stand.
Oh, gosh.
Proceed.
I would like to call Christian Chavez to the stand.
Okay.
Yes, sir.
You are Christian Chavez, correct?
Yes.
Okay. Give me a second. I'm bringing this shit up again. As you see, I had all the perfect questions.
Your Honor, he's taking too long.
Okay. Did me and you have a conversation on February 26, 2026?
Yes, we have conversations all the time.
Okay, but did we talk on this date specifically?
Yes.
During that conversation, you offered to perform a service, correct?
Correct.
You did not say you were joking, did you?
I don't remember.
You did not place any conditions on that offer.
Nope, no conditions.
Okay. That's all, Your Honor.
Defendant, do you have anything to say to the witness?
Your Honor, I would like to call Buster Chuz to the fucking stand.
I accept. I'm here.
All right. What would you like to say to Buster Chuz?
Buster Chuz, is that your real name?
It's the only name that matters.
It's the only
But
name
is
that
it your real
matters,
name?
right?
Real name is David.
Now, if this were a verbally binding contract, do you recall me saying your name?
You call me by a lot of things, but you've never called me by my name.
So wouldn't that void this promise if I didn't give it specifically to David James Coyle?
No, that would not count. Because like I said, me and you have done business dealings beforehand and you've never called me by my name.
Are these business dealings trackable, traceable?
They're not relevant to the court, but yeah, they are traceable.
That is all, Your Honor.
Your Honor, can I call Christian Chavez back to the stand?
Yes, you may.
Okay. Hey, buddy, you better have a comfortable seat. I got a lot of questions for you.
Oh, fuck, okay.
You did not follow through on what you said, correct?
Correct.
You never attempted to perform the service, correct?
Correct.
You didn't apologize before I confronted you, correct?
Incorrect.
Really? Can you please tell the court when you apologized?
Last night.
Your Honor, he's making shit up.
You have any proof that he's not making it up?
I'm here today suing this guy for $68,000. You think if I got what I wanted, I'd be here?
There's no evidence of me not apologizing.
Yes, there is. I can give my whereabouts for last night because I have photos of it. And photos
Yeah, but you
show
didn't submit them.
I didn't need to. Because they're not relevant to... What I was doing last night is not relevant to this case. Wait, it's my turn to talk! Anyway, back to the questioning. You understood I was taking you seriously, correct?
No.
You did not correct me or say not to rely on it, correct? You did not withdraw
no.
the offer before I relied on it, did you? We can go back to the evidence.
No.
Yeah, no, you did not. You never warned me not to depend on you, correct?
Correct.
You never told me to seek alternatives, correct?
But I never avoided you.
But you never told
Avoided
me.
you to seek.
You never told me to find someone else. You never.
Correct.
You never suggested I shouldn't rely on you. Oh my god. At the time, you were the only person making that offer to me, correct?
Incorrect.
Oh, really? Who else?
I believe the judge
Bro's giving up.
has offered.
Let the record show
Sorry.
the judge has never offered that shit before. Believe me, I've tried. You don't start with Christian, you stop with them, alright? Okay. Other questions. So, your testimony is that you made a promise that you never intended to keep.
Yes.
That's all, Your Honor.
All right, defendant.
Even though it was a promise that I was not willing to keep, it still does not. It's still void when it comes to promissory estoppel.
Are you hearing this
Also,
shit? Dude, he's going on still. He's admitted. He's already admitted he's in the wrong.
I never admitted I was in the wrong.
I thought I muted myself. My bad. I was trying to talk to the stream. But no, you did admit that you're in the wrong. Fuck that. You did.
No, I did not.
Can I go back to the part where he answered basically no. And he just said, I never intended to keep that promise.
You can go back to the footage and see if it's there.
I'm currently live streaming, but fuck it. I have an idea. No, I can't. That's gonna fuck everything up.
Okay.
It is there. If you just scroll back to what he just said when he started his thing, he made a promise he never intended to keep.
Sustain.
Anyway, please
I
continue.
also didn't. But even though I said I didn't promise, or I didn't intend to keep me on that promise, neither did I also think
Oh, I got this in the bag.
it was going to be a legally binding promise. It was not a serious commitment intended to create legal obligation.
Objection. Nonsense.
Your Honor, even accepting plaintiff's narrative, the elements
Could
of
you
permission.
can you explain to me why it's nonsense, plaintiff?
Because all those questions I answered, he spoke the truth on. He already answered when I said, you understood I was taking you seriously. Okay? You did not correct me, nor to rely on it. Okay? All these questions I just asked him, he did not withdraw the answer before I relied on it. He never. Okay? Every single time you can go back to the, I will even go back on the court evidence page and I will show you when I said right here, right now. All of it. Everything. It's nonsense. He's going back on what he said earlier. I asked him these questions and he answered these questions. Now, Your Honor, his poor defense is probably due to, he's poor as a person, so he couldn't afford a good lawyer.
Your Honor, relevance?
You're right. I just want to throw that out there.
Sustained.
Anyway, the defendant can continue his case.
Your Honor, even accepting plaintiff's narrative, the elements of promissory estoppel are not satisfied. There was no definite promise intended to induce reliance. Any alleged reliance was unreasonable and resulted in no sustainable, fuck, I'm retarded. Legal.
So then we
I don't
just
even know how to read that.
Redartation.
Impairment. Yes. Yes.
Objection asked and answered. Objection argumentative. Objection cumulative. Objection cumulative.
Fucking mute this dude. He's already said two objections.
No,
Fuck this dude, bro.
you can make as many as you want if he accepts them. And by him letting me explain my point, he's let me do it. And I have all of these because they're all just the same thing.
Mm-hmm.
And basically, it lands on one thing. He's going in circles, Your Honor. He keeps making the same point with no new information. I keep bringing new information. We are going in circles right now.
It has been going in circles a bit, thanks to the defendant.
Because he didn't submit any evidence. Your Honor, if you would allow me, I would like to show more of my evidence. Because clearly, he's just going to keep going in circles.
Yeah.
Okay. If we go 226, 1:34 a.m., he said, I do sexual favors. Time to open your hole for them. How else should we do this? Let's see. I think that's just Skankaroni. Oh, here's one. Look at this house. That looks dope as fuck. I'ma blow you. Beach mansion. Use my cock as a pogo stick. You bet your sweet bippy I will. You see, do these seem like agreements? Like he's going to. He's going to. I could keep going if I wanted, Your Honor, but I'm going to save some of this evidence for later.
Is that all?
Yep.
All right, defendant.
Yep.
Do you have anything to say before my final judgment?
Well, wait, hang on. I think we should all
There's another trial.
we should all be allowed to have closing arguments.
Okay.
So, if that's the case, I'll let him do his closing argument first.
Your Honor. Oh, my closing argument first? I don't have a closing argument, but I'll get one. One for.
What do you... He just called a recess. Did he just call a recess?
What? No.
You basically just
I didn't
did
call
it.
a recess.
What do you mean you don't have a closing argument? He just admitted he doesn't have a... Does that mean he doesn't get one? Does that mean he doesn't get one?
If you can write one up before.
I already
you're
got
done
it. Anyways,
with
Your Honor, repetition does not transform vague statements into a clear, definite legal promise. He still must prove a clear and definite promise, reasonable reliance, foreseeable reliance, sustainable deterrent. More screenshots only potentially help element one. Yeah. They don't automatically prove for reasonable reliance, foreseeable medical harm, sustainable damages. Even if the statements were made multiple times, they lack specific. I can't even fucking read that. Specificity. Yeah, and were not reasonably interpreted as binding legal obligations. Your Honor, this case is not about embarrassment, emotion, or repetition of words. It is about whether the legal requirements for permissionary estoppel have been met. They have not. Promissory estoppel requires a clear and definite promise, reasonable reliance, foreseeable reliance, and substantial deterrent. The plaintiff has failed to prove these elements. First, there was no clear and definite promise.
First
The
off, I
the
have
statements presented
made
were
this
vague,
promise so many
informal, and
fucking
lacked
times.
specific terms.
So
There
many
was
fucking
no
times.
written
I've been
agreement,
going
no
back and forth
defined
with this
conditions,
shit.
no timeline,
But
no exclusivity.
I have my closing
and no
argument.
legal language
He's
indicating
just gonna keep
an
yapping
intent
and
to create
yapping.
a binding obligation.
It is just the same
Second,
thing
even
over
if
and over
statements were
again.
made, any reliance was not reasonable. A reasonable adult would not interpret casual, intimate remarks as legally enforceable commitments. There was no
You can't
exchange of
object to
value,
that.
no formal agreement, and no
I don't
circumstances
think I can
suggesting
object during
legal
a closing
seriousness.
argument.
Third, there was no foreseeable or substantial deterrent. The alleged harm is temporary discomfort, while the plaintiff presents medical paperwork. Wait, forgot about that. They didn't. There has been no expert testimony establishing causation or permanent injury. There was no
But you both
physical
have
interaction.
agreed that this has been a medical issue.
There was no physical interaction. There is no evidence that I caused his condition. The plaintiff admitted receiving similar services days earlier, introducing alternative explanation. Finally, courts do not enforce personal intimate conduct as contractual obligations. There is no legal duty owed, no breach of duty, and no
This is gonna be hard with that last point.
injury established. The burden of proof
But I think
rests
I got
entirely
it.
on the plaintiff.
I think I got
Speculation
this.
and discomfort are not sufficient to impose liability. For these reasons, I respectfully request judgment in my favor. That is all, Your Honor.
Alrighty, plaintiff.
I want to point out that there are no objections and closing arguments. He can ask his lawyer, as proof of that. So, I will now do my closing argument. Your Honor, at its core, this case is about responsibility for words that were meant to be taken seriously. The defendant made a direct representation to the plaintiff. It was not withdrawn, it was not clarified as a joke, and it was not conditioned. It was presented as a serious commitment. The defendant now argues that there was no contract, there was no duty, the consequences were not foreseeable, and there were no other options. But this is not a breach of contract claim. It's a claim based on promissory estoppel, a doctrine that exists specifically for situations where a promise induces reliance, even in the absence of a formal contract. The question before the court is simple. Did the defendant make a promise that he expected would be taken seriously? Did the plaintiff rely on that promise? Did harm follow when that promise was not honored? The evidence shows that the promise was made, it was not retracted, reliance occurred, and the defendant failed to follow through. This defense has relied on argument, not evidence, to suggest alternatives. Remote causation and lack of duty, but speculation, what might have existed, not defeat actual reliance on what was said. The law does not permit a party to induce reliance, then avoid responsibility by later claiming it was casual or informal, or not legally binding. Words matter. Representations matter. Reliance matters. For those reasons, plaintiff respectfully asks the court to find in his favor. Thank you, Your Honor. Wipe the floor with him.
After hearing everything and all the evidence, seeing physical evidence, I can't help but say that the defendant has been tried as guilty above all charges.
Your Honor, I did not. There's no evidence of me saying I understood.
Hey, listen here, Brunette Appeal, you lost.
No.
However,
No, that is bullshit.
if you want to keep going, you want to keep this going, why don't we take it to trial?
Let's take it to trial. And I would like
Let's
to
take it
add
to trial
one more
then.
thing.
Okay.
You never asked for my reliance. I never knew you had reliance on it. You never told me that you had reliance on it.
Barely see my breath.